Yes. Suit for bare injunction. Then?
The title has been categorically disputed in the written statement by the defendant.
That is not necessary. In every case where Anatullah Sudhakar doesn't apply in every case. Inevitably in a suit for injunction, title is always disputed. The burden is on the plaintiff to prove.
That is the entire case.
Then the suit was decreed. Yes.
First appellate court reversed the findings. It held that the plaintiff also failed to show their ownership.
Now the High Court has restored the decree.
That is the issue. We kindly have paragraph 15 of the High Court judgment at page 15 of the paper book.
Not necessary to seek a declaration always.
I understand.
Now why have you come up in SLP? The trial court decree is restored.
The trial court decree is restored not on the facts of the case, it is solely on the basis that the appellate court went into the issue of title.
Not necessary to go into the issue of title.
Just for a minute,
now trial court found possession with the lawful possession with the plaintiff. Injunction was granted.
That is the issue, my lord. If my lord kindly peruse the trial court judgment against the appellate court judgment.
If you want, you go and file a review if you have any difficulties.
Kindly give me 2 minutes, my lord. Indulgence. The High Court has set aside the judgment, my lord, solely on the fact that the appellate court need not go into this.
Correct.
Fact of remains, my lord, that the appellate court took pains. The High Court says so. The appellate court took pains, my lord, may kindly have...
Not necessary to go into the title.
I understand. My lord, may kindly have just para number 11 of the High Court judgment itself. High Court judgment itself at page number 12.
See the two substantial questions of law at paragraph 1 of the judgment.
My lord, with all due respect, my lord, the substantial questions of law have been framed in such a way, my lord, that they are going into the facts. My lord, on the very the first substantial question of law, the finding on the High Court says, my lord, at para number 11 of page number 12, my lord. It is in the my lord.
No, nothing. Please, you want you withdraw and go to the.
My lord,
go and file a review if you want. Otherwise, we are not interfering.
1 minute indulgence, my lord. But para number 11, my lord. Just para number 11, page number 12, my lord. It is in this backdrop that of the facts and circumstances, I shall now examine the substantial question of law. The first substantial question of law is that lower appellate court is incorrect in disbelieving Exhibit A1 without assigning any valid reason. I must say that the first appellate court did not disbelieve Exhibit A1. Exhibit A1 is the only document that they relied upon to show, my lord. It took pains in comparing the A1 and mentioned plan and considered the plain schedule and considered the oral evidence and then concluded that the plain schedule property is not the one covered by A1, my lord. It is a matter of record that both courts considered Exhibit A1 and have not condemned A1. So the sole document that is the basis of the proof that is being used by the plaintiff, that the appellate court said this does not give you the title. My lord, may kindly give me 1 more minute. I'll just show the appellate court's findings on this.
No, need not. You go to the second question of law.
My lord, in the second question of law, my lord, is para number 15, my lord. It says, record indicate at page number 15, my lord, at the bottom. This is the final finding that the Honorable High Court has held. Record indicates that before the trial court, no issue was settled with reference to title of the plaintiff.
Not necessary.
I understand, my lord. I clearly understand. I have, my lord, if my lord may kindly grant me.
In every case, Anatullah Sudhakar Buchi Reddy will not apply. Yes.
There is a subsequent judgment of this Honorable Court which says vacant land and de jure possession.
That means nobody can file a bare injunction suit. If you are saying in every case for an injunction, declaration relief also has to be.
Separate titles that have been played, my lord.
Now, Exhibit A1 is proved by the plaintiff. Yes.
The appellate court, my lord, is the final court of court, my lord, held that Exhibit A1 does not match with the plain schedule property. That is the only reason.
That has been now, you see, in paragraph 13 they have set. Yes, thank you. How many days delay? Any delay? All right. We have heard learned counsel for the petitioner. SLP is dismissed.
We kindly consider one small fact, my lord. One small fact.
Now it's over. Thank you.
Yes, I understand, my lord. Kindly consider one small fact, my lord. There is a categorical. They failed to prove their ownership, my lord. The appellate court.
Not necessary. Possessory title, if they prove it is sufficient.
Also, my lord.
That we don't know at this stage. Yes.
The appellate court said there is no possession.
Yes, who is there?